Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk about whether or not marriage matters when it comes to estate planning. Before I get to that, though, I want to remind you, if you have any questions about estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay. So I had a conversation today with a client who is in a new relationship, and they are thinking about getting married or not getting married. They're not sure, and they wanted to talk about like the benefits and the consequences of being married or not being married when it comes to estate planning. And I thought that would be a good subject for us to talk about, because I actually just had the almost exact same conversation like 3 days ago with somebody else. And there are sort of like a few different considerations when it comes to what you want to do and how you want to approach this issue. I'm going to take it from like the cold-hearted, what's love got to do with it kind of place, okay? So we're just going to just tell how it is. Feelings aside. So generally, there is not a lot of upside from an estate planning standpoint to being married. There are some things that you can do when you have a spouse that you cannot do when you don't have a spouse, but those things are not going to apply to most people because your assets have to be very significant, okay? They have to be pretty high. And there are other things that you can do to offset those things that you can't do with just other tools and other strategies, okay? There is also an unlimited marital exemption when it comes to paying estate taxes, both for Washington State and at the federal level, which means if you are married and you die, you can give as much of your assets as you want to your spouse and not have to pay any taxes at that time. If you are not married, then you lose that exemption. And if you have significant assets, you could potentially be looking at an estate tax bill when the first partner dies, if they have significant individual assets. Okay, so that's the main thing. If, however, you are not going to get married, there are certain things that you will definitely want to do from an estate planning standpoint, because being married gives you some legal sort of abilities that not being married does not. Okay, so the first thing that you'll want to do is make sure that you both have a power of attorney in place and you name each other as your power of attorney. This way, if somebody gets in a car accident, the other person can access the bank accounts and pay bills and like do the things that they need to do. It doesn't give the power of attorney the ability to use the money however they want. They have a fiduciary duty to the person who's giving the power. But I've definitely seen situations where someone gets in a car accident and the partner, right, the girlfriend or boyfriend or however you would describe them, has a hard time paying rent or paying the mortgage because the person in the car accident had an individual bank account, and now that can't be accessed, and so all those funds are essentially frozen for a while. Okay, so that can be a problem. You also want to do the same thing with medical power of attorney. Using this car accident example, the girlfriend or boyfriend comes in and the hospital will not give them any information because they're not married and there's no release of that information from the person that's been in the car accident. Okay, so power of attorney, medical power of attorney, super duper important. And you also want to make sure that you have a will or a trust or some sort of, or your beneficiary designations are up to date, or some form of all of these is set up to make sure that the person that you're with gets the assets that you want them to get if you die or when you die. Because if you don't do that, your partner is not considered to be a member of your family. So if you don't have a will or if you don't have some other means of conveying your assets to that person, you will look to the law. And what the law says is, if you have kids get it all. If you have parents, then brothers and sisters, then nieces and nephews. At no point in time is girlfriend or boyfriend involved in this equation. So those are the main things to consider. I've also had discussions around real estate and how to treat that. There are many different options that you can sort of take advantage of when it comes to real estate and non-married couples, but it's kind of an individual conversation, right? Because different things are important to different people. So if you're curious about that, let me know. I'm happy to talk to you about it individually. Okay, that's it. Okay, so that's sort of what you need to know. You definitely want to have some estate planning things in place. There aren't a lot of significant advantages to being married necessarily when it comes to estate planning, but before you make if your choice of being married is just estate planning based, I'm happy to talk to you about it. If you want to talk about love, you probably have to go to a therapist. Okay, that's not my forte, but I digress. So anyway, hopefully that helps. If you guys have, as always, if you like this video or like this audio, hit the like button if you have a space to do that. If you don't want to miss any episodes in the future, hit the subscribe button. And if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, that's it for today. As always, I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. Appreciate you, and I'll talk to you again soon. See ya.